Good morning, everyone. Today I'll be sharing some key learnings from a very important case called BOLITHO and BANKSIA securities about our obligations to ensure that costs are reasonable and proportionate, as per Section 24 of the Civil Procedures Act. This presentation will briefly discuss the decision by Justice Dixon and lessons that we can learn from his decision. So what were the judgments of the case? The lawyers in BOLITHO did several things clearly wrong. They rendered invoices for the work that wasn't done, inflated the time they spent on tasks, and failed to regularly provide bills to their clients. This was all done to fraudulently capture a larger slice of a class action settlement, which litigation funders were entitled to. All that conduct is clearly wrong, but the judgment also provides some general guidance about how to comply with Section 24, which is useful to us as lawyers. The first lesson is that we should scrutinise the costs of people who we engage. The lawyers in BOLITHO tried to run an argument that the overarching obligations didn't require them as solicitors to monitor whether the costs charged by third parties, such as counsel, complied with the costs agreement. However, the court made clear that solicitors must scrutinise disbursements to be charged to their client. So that's the first lesson. Anytime we have an engaged counsel, an expert, or paid for a third party to conduct company searches, it is our responsibility to make sure that the costs incurred by those parties are reasonable. The next lesson is that lawyers are required to maintain accurate and detailed records of their work. The case shows that it is important for us to record our time contemporaneously and make a clear narrative of what we've done so the client understands what they are paying for. Furthermore, we should give bills regularly and update clients about costs. While this is a common day-to-day activity for most lawyers in their profession, it should not be undermined and completed honestly and thoroughly to ensure that costs of legal assistance are neither undervalued or overvalued. Lastly, we need to consider factors such as complexity and urgency of matter when formulating legal costs. For example, we can comply with the considerations of complexity and urgency of matter when briefing counsel. With these considerations, we can decide how many counsel members we require, or if we need a senior counsel at all, to ensure that clients are not paying unreasonable amounts for their case. I appreciate your time today and hope that this discussion of BOLITHO vs. BANKSIA was both informative and helpful. Have a great day.